Major breaking news, the Washington State Commissioner for the Supreme Court of Washington has entered an order staying, which means freezing, the lower court decision by the Superior Court that held several weeks ago that quote-unquote large capacity magazines, the ban on large capacity magazines by the state of Washington was unconstitutional. But rather than allowing that decision to go into effect, a commissioner for the Washington State Supreme Court has stayed it, which means has made it not legally effective as of now, which means that these magazines that hold more than 10 rounds in Washington State remain illegal, notwithstanding the fact you have a 55-page decision that says this violates the state and the federal constitution. Let's break down this decision by the commissioner and his 80-page opinion that stays the decision by the lower court when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many Second Amendment books, including Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so unfortunately for our friends in the Second Amendment community in Washington State, a commissioner for the state of Washington's Supreme Court came out and has stayed the decision by the lower Superior Court that had held that magazines that hold more than 10 rounds, so-called large capacity magazines, and the fact that they had been banned by the state of Washington, that lower court decision had held or ruled that the ban on these was unconstitutional under the state Supreme Court, under the state constitution and the federal constitution and so on. Nevertheless, you may recall this, the commissioner in approximately an hour and a half issued a decision that stayed, meaning the lower court decision never went into effect except for maybe 90 minutes. And now we have the more robust opinion by the commissioner after an argument last week where the commissioner basically said that there's no way he's going to allow this order by the lower court to go into effect because he does not want there to be a freedom week, if you will, in the state of Washington where people can go out and actually buy magazines that hold more than 10 rounds. Basically, I think his argument is based on public policy grounds, which is kind of stupid, but we'll get to that in 1 second. Nevertheless, the commissioner today has just issued an 80-page decision, I'll put a link to it down below, explaining why he's going to continue the stay and not allow the ruling by the lower court to strike down the ban on these magazines to go into effect. Basically, if you look at this opinion, the way I think it should have been written is he should have written this opinion starting off with the words "Dear Diary," because half of the opinion, or not maybe not half, but enough of the opinion, in my opinion, was navel-gazing, talking about his past, musings about his personal stuff. Just to give you a couple examples why I think he should have started off this opinion with "Dear Diary," let's go to some of the things he wrote in it. He first of all apologizes to Washington's indigenous tribes. He writes, "It should be noted that during a fleeting portion of oral argument discussing the territorial and early statehood period, I offhandedly mentioned suppression of this region's indigenous people. Immediately after oral argument, I realized with considerable regret I had not given enough weight to that dark part of a history. I take this moment to fully recognize the harsh and cruel subjugation of Washington's indigenous tribes and their people during the territorial and early statehood period. The intergenerational trauma of that subjugation and oppression is keenly felt today. We must never forget that." Period, close quote. Well, I'm not going to get into a debate about American Indians, but I will say that they were referred to as the merciless Indian savages in the Declaration of Independence, which, yes, occurred before the Western expansion. But nevertheless, this is where this commissioner decides to go, talking about how he feels and what he thinks about an aspect of American history. But nevertheless, let's carry on. Then he goes on to talk about another thing that should have been discussed. So he continues to talk like it's his Dear Diary. Here's what he writes in footnote 5. He says, "One of my law school classmates, an Army veteran, as if being a W-2 employee means anything to me, meaning a W-2 employee working for the government, I don't care. That's great, but it doesn't speak to the Second Amendment." But you notice how they always slide in, hey, he carried guns for the Army, imply that stuff. So anyway, this is what the commissioner wrote. "One of my law school classmates, an Army veteran, liked to take his vintage 303 Enfield out for deer hunting. It is ideally suited for that purpose." Who cares? Why is he talking about his law school roommate? He needs to apply the Supreme Court precedent of Heller and Bruin. Not that hard. And yet here he is musing about stories. Then he goes on to specifically admit that he wants to engage in this sort of navel-gazing and personal introspection of life in footnote number 4, where he talks specifically that the reader will note that I make some remarks based on my lifetime experience with firearms. Oh, isn't that interesting? But we don't care what you think about firearms. We want you to know something about the law, the Supreme Court law, you moron. No one cares about your expertise on technology. What you need to do is to apply the law. That's why you got a law degree. That's why you read the law books. That's why you apply it, right? That is your job, to actually apply the law. So why don't you skip over your quote-unquote understand about the history of firearms and firearms technology and do your job as an attorney, as a commissioner for the Washington State Supreme Court, because your decision here is embarrassing not only yourself, it's embarrassing your colleagues, your superiors on the Washington Supreme Court, because it is apparent, and I can assure you the U.S. Supreme Court will take note of this. The moronic statements you are made are so outrageously clear that either it means even if we explain the law to you, you're not capable of understanding it, or perhaps the problem is that you just don't care. But either way, this is the sort of thing that the U.S. Supreme Court is going to take note of and will increase the odds of them taking one of these cases very, very soon to clear up this kind of misbehavior, either out of ignorance or feigned ignorance or something else that keeps causing these lower courts, including apparently the commissioner of the state of Washington Supreme Court, to continue to screw this up. But let us carry on. Of course, now we turn to some of his big mistakes as to why he decides to say that the law is effectively constitutional. He goes on to say that magazines are not arms. Now, obviously, magazines are arms for countless reasons, but this is what he writes, quote, "One can argue that an LCM is a weapon if you whack someone on the head with it, but in reality, an LCM is an optional component of a firearm, not a weapon or arm standing alone. Yes, a semi-automatic firearm will not function without a magazine. However, it will work just fine with 5 or 10 round magazine. It just has to be reloaded with a fresh magazine more frequently than with an LCM." Of course, this is moronic because remember that Heller says specifically that once an arm is in common use, you can ban it, period, full stop. And remember, the District of Columbia had this commissioner actually read the Heller case. The District of Columbia literally argued this exact point. They says, look, we can ban handguns because we're letting Americans in D.C. have rifles and shotguns, and because we're letting them have rifles and shotguns, it's okay for D.C. to ban handguns because we're giving them this option. And the Supreme Court says absolutely not. It's no defense to a Second Amendment right to bear arms case to say that you are letting them have some weapons but not other weapons. And that is basically what this commissioner is saying here, that because you can have 5-round magazines or 9-round magazines, that's fine, but that violates the Heller decision. Moreover, of course, there's nothing in this opinion that I saw where he addresses the most obvious point that when you ban a magazine that holds more than 10 rounds, it's not a magazine ban. It is a magazine ban, but it's worse than that in one sense. It's actually a firearms ban. Think about what I've said. We've talked about this, but this may be, above his pay grade. I don't know. You'll tell me. Take a look at his opinion, see if you disagree with my opinions on all of this. But if you look specifically at a magazine ban, if you ban magazines that hold more than 10 rounds, you have actually caused a gun ban, a firearm ban. And why do I say that? We've talked about this before. When you ban a magazine that holds more than 10 rounds, you have banned an entire class of firearms that is capable of firing more than 10 rounds without being able to be reloaded. Now you not just ban a magazine, even if you want to have a game about it being an arm or not, set that issue aside. It clearly is, but set that issue aside. It doesn't matter because the state of Washington has banned, in this case, an entire class of firearms by banning magazines that hold more than 10 rounds because they have banned an entire class of firearms that are capable of firing more than 10 rounds without needing to be reloaded. That is a gun ban. Not just a magazine ban, that is effectively a gun ban that violates the Heller case. And by the way, we know that modern day firearms are protected because that's what Heller and Bruin all refer to. And of course, modern day firearms, specifically the handguns covered in Heller and referenced in Bruin, because Bruin was discussing, although it was not an arms ban case, Bruin was talking about these individuals that wanted to carry handguns in public for self-defense. So there was a discussion of that insofar as confirming that handguns are in common use and thus cannot be banned. So there's no dispute on that in Bruin. Nevertheless, the reality here is that this commissioner is simply not following the law. Then he goes on to say basically he spends a lot of time talking about how these magazines are involved with mass shootings. But again, this is not the standard because the Constitution doesn't measure your rights by virtue of how things are misused. The Supreme Court has repeatedly said this, but this commissioner obviously never read the opinions, or if he did read the opinions, he must not understand them, or he simply doesn't want to follow them. Here's what he writes. The difficulty for the state is that it cannot prove a negative, that keeping the stay in place will prevent a mass shooting. However, the historical record shows that LCMs greatly increase the number of fatalities and injuries inflicted in a mass shooting, and that the frequency of such incidents has grown in recent years. Crap. First of all, he should not be discussing the good and the bad of guns, because the U.S. Supreme Court in Heller specifically says at the end that the decision, the good and the bad of guns, and the balancing that took place has been done by the founding generation, and it came together in the Second Amendment, for example. The balancing has already took place by we the people in 1791. So you can't rebalance it, and the Supreme Court was very clear in Heller that says that government agents, including courts, are not allowed to weigh the good and the bad of guns because the Constitution has already done that, and it's given rise to the Second Amendment and a Washington state version of the same. Moreover, again, you do not measure constitutional rights by how they are misused, because somebody can go out there and engage in obscenity, because someone can go out there and engage in fraud with their words, because someone can go out there and defame someone with their words. That doesn't mean that I lose my right to free speech. Obviously not, okay? So the reality is this commissioner doesn't seem to care. He is also engaging in something you're absolutely not allowed to do in gun-related cases. That is to engage in interest balancing at all, because the only reason why you're talking about mass shootings is because you're trying to say there are bad public policies associated with these weapons. And if you're talking about the bad of these weapons, guess what? You're interest balancing, which you're absolutely not allowed to do, unequivocally not allowed to do in Second Amendment related litigation. Furthermore, it's also simply just logically insane, if you think about it, that any weapon that makes the life or the job of engaging in a crime easier for the criminal, anything that makes it easier for a criminal to commit a crime, it's more important that Americans have access to those same arms. Because remember, the criminals pick the time and the place and who they attack. You, the victim or potential victim, don't have that luxury. You naturally are reacting to criminal conduct. So to the extent that an arm, including a magazine that holds more than 10 rounds, might conceivably help a criminal do bad things, it is equally and in fact more important that you have access to those weapons so that you can fight off criminals doing bad things. Because I can assure you, as Cesar Beccaria taught us and taught the founders in the 18th century, an unarmed man can much more easily be attacked than an armed man. And he specifically talks about in his 18th century work that the idea that someone that wants to commit a malum in se, terrible murder and rape or whatnot, is going to comply with an arms law, such as a ban in Washington on magazines that hold more than 10 rounds, is simply absurd to even think this is possible. So the bottom line is that this decision by the commissioner is full of a lot of throat clearing, a lot of navel gazing. It's 80 pages long. I suspect the reason why he wrote so many pages is because he's very nervous about the fact that he's been tasked supposedly with this obligation to oversee and override a major 55-page decision by a judge. When you're just a commissioner overriding a judge, it seems highly unconstitutional and illegal to me. But again, it's a Washington state law issue, so I can't speak to all those. The bottom line is, I feel very sorry today for our Second Amendment friends in Washington state, but there's nothing you can do about it right now. I think there are other Second Amendment cases in line to the U.S. Supreme Court that will get there likely before this case of Washington state versus Gator custom guns. But nevertheless, it's a terrible blow to see this kind of moronic things. We can only hope that the dumber these decisions are out of places like the state of Washington, the more likely it is the U.S. Supreme Court will step in to fix this, because they will just shake their head and realize how absurd some of this stuff is going on around the country, and they will want to fix it. Let us hope and pray that is what the U.S. Supreme Court does with one of these quote-unquote assault weapon, which is a semi-automatic rifle cases, Bianchi or Illinois or one of these cases, coming up soon. But again, only time will tell. In the meantime, good luck to our friends in Washington. Washington. You're going to have to go to the Washington Supreme Court, see what they say. I'm not optimistic because, you got a couple cities in that state that control the rest of Washington, which is essentially this America. Unfortunately, you're not controlled by Americans, it seems to me. You're controlled by urban elites that think you are a serf, a peasant, and not a citizen of Washington State or the country of the United States. All right, folks, hope you learned a little bit something here today. Make sure you subscribe to the Four Boxes Diner. Follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.